Start. This writ appeal is filed questioning the correctness of the judgment of the learned single judge, upholding the validity of subsection 7b of the section 7 of the Kerala General Sales Tax Act 1963 and Rule 22A2 of the Kerala General Sales Tax Rules 1963. Before going into the merits of the legal contentions, we may look into the facts. The appellant is a company registered under the Indian Companies Act 1956 having its registered office at Mumbai. It is a dealer registered under the Kerala General Sales Tax Act 1963. Appellant is a manufacturer cum dealer of electrical and electronic goods. A customer from the Ernakulam placed on order with the appellant for supply of one whole body CT scanner at a total cost of rupees 55 lakhs. As per the above order, appellant had to supply the CT scanner from its factory to ex-Goa and carry out the installation of the equipment at free of cost at Cochin. Installation work was incidental. According to the appellant, transaction was in a sense in interstate sales accessible at Goa. Appellant has remitted rupees 1 lakh as tax at Goa. Details of the contract can be seen from Exhibit P1 and P2 and Exhibit P3 is the invoice, but by Exhibit P4 dated 21/10/1999, appellant's customer was issued with a notice directing them to deduct a tax at 8% on the bill amount and remit the same with 10% surcharge on it. By Exhibit P5 dated 6/12/1999, appellant requested to issue a certificate for non-deduction of TDS as it is mainly a direct interstate sale and appellant is registered dealer. By Exhibit P6, appellant was informed by the third respondent that provision of CGST Act has no application since the appellant supplied the equipment and erected it and therefore pay tax under the KGST Act. Appellant's representation to fourth respondent was also rejected by a one-line letter stating that no intervention is required at that stage. Para. Every awarder shall deduct a tax at the rate of 2% in respect of civil contracts and 5% in respect of other contracts from the payment made by him to any contractor liable to pay tax under Section 5 and who is registered under Section 13 and at the rate of 70% of the rate shown in the fourth schedule against such contract where the transfer of the goods involved in the execution of works contract is not in the form of goods or as the case may be at the rate applicable to the goods under this act where such transfer is in the form of goods from any other contractor liable to tax under section at every time including advance payments and remit it to the government on or before the fifth day of the succeeding month from the date of such deduction in the prescribed manner. Stop.